Thank you. I'll not read them out as they are already on record and have been referred to by all my colleagues. I'll also refer to them one after the other. I find myself substantially in agreement with the arguments and conclusions by the Honorable Chief Justice Kome, President of the Court, on some issues. Just as well, on some, I'm of divergent views. I render my opinions and pronouncements on the issues as delineated by the court. The first question is regarding the basic structure, whether it's applicable in Kenya, and if so, the extent of its application, whether the basic structures of the Constitution can only be altered through the primary constitution power, and what constitutes the primary power. In answering and determining these questions, I trace the history of what is the basic structure and what it comprises of in the framework of a constitution. I trace that history globally from the Federal Republic of Germany to India, the US, France, then also to the other countries like Malaysia, Singapore, Bangladesh, Uganda, and many more. Some of these states, particularly the ones which came to consider later the basic structure, some were disinclined initially. That's the courts in those countries, but later some of them adopted and accepted the said doctrine. I finally came to the applicability of the said doctrine of basic structure to Kenya. I followed our journey of constitutional making from the CKRC to the Bomas Conference. During the said process, Justice Ringera, as he then was, grappled with the question of the basic structure of our repeal constitution. He concurred with the majority pronouncement in the case of Kesavananda that Parliament did not have the power to alter the basic structure of our constitution. This was in the case of Timothy Njoya and others versus CKRC and another. The application of the doctrine also arose in the case of Patrick Ouma Onyango and 12 others versus AG 2008. The court, consisting of Justice Nyamo, Wendo, and Mkule, found and declared that the basic steps in constitutional making, they declared the basic steps in the constitutional making. Then there was the case of Commission for the Implementation of the Constitution versus National Assembly of Kenya, 2013, where Honorable Justice Lenaola, as he then was, analyzed the question of the basic structure of the Constitution, although that was not really a direct issue, and also the issue of its applicability was not before the court. I just want to refer that it was considered and it was a known principle before this case, which is before us. Then there was a case of Priscilla Ndululu Kivuitu and another versus AG 2015, wherein the three-judge bench, Korir, Mumbi, Ngugi, and Odunga, held that some amendments under Article 255, 1 or Article 257 can only be done with the involvement of the citizens by way of referendum. They relied on the sentiments expressed by Honorable Ringera J. in the Njoya case. The three judges, I'll refer to paragraph to what they said. I'll go directly to that, what they said. they say that we agree with the sentiments expressed by Ringera J. in Joya 2 that an amendment that upsets the basic structure of the Constitution could not be effected by Parliament without involving of the people. In a country like ours, which has a history of disrespect for the sanctity of the Constitution, the jurisprudence propagated in the Joya 2 case was necessary. This may explain why the people of Kenya, aware of the frequent and frivolous amendments to the repealed Constitution provided in Articles 255 of the 2010 Constitution, and I refer to the contents of Article 255, where strict conditions were given before any amendments could be carried out, and I don't have to refer to that. It is clear from the above cited provision that there are amendments that can only be done with the involvement of the citizens by way of a referendum of Article 255(1) or popular initiative involving at least 1 million registered voters, Article 257(1). So it means that the judges themselves in this case, referring to the basic structure, identified Article 255 as containing principles of basic structure. Even where Parliament has been mandated to amend the Constitution, it can only do so after the amendment bill has been subjected to public discussion, Article 256(2). The voice of the people is a voice that cannot be ignored when it comes to the amendment of the 2010 Constitution. We wonder, and they continue, we wonder whether in light of the provisions in 2010 Constitution, the proposition that Parliament cannot amend the Constitution in a manner that may result in the distortion of the basic structure, again they use the word basic structure, still has a place in our jurisprudence. However, this is not an issue that has been taken up with us, and we will say no more about it. So I'm just giving the background that these issues have been before the court, but not directly. But now, in our case, it is directly before us, and we have to deal with it. There's been a discussion and contestation of whether this basic structure is a doctrine or even a principle. An uncontentious example of popular doctrine, for instance, is that of the separation of powers in a tripartite form of separation comprising the executive, judiciary, and legislative arms of government. We credit the French jurist with a long name, Charles Louis de Secondant Baron de la Brede de Montesquieu. I'm not very good in French, or in fact, I don't know French at all. Or Montesquieu, I read him in history, simply referred to as Montesquieu, as the father of the doctrine. This doctrine is embedded in our legal system by direct reference in various, and we have adopted it even in the structure of our Constitution. However, even as we make reference to the doctrine of separation of powers today, it is not to say that the doctrine has not evolved since 1748, or that it is only Montesquieu who discussed it. In Kenya, we have not only laws, however, that incorporation was with some modification to suit our peculiar circumstances, such as the addition to the independent commissions and offices. Yet in doing so, we have not explicitly provided for it, or even defined the doctrine of separation of powers in our laws. Still, it is evident that we have applied it. So the question of the basic structure as a doctrine, what is it? What does it encompass? Is it applicable in Kenya? This is the duty we have, and we cannot just dismiss this. Many times it has been said that this doctrine of basic structure, the origin came from the case of Kesavananda, 1973, whereby the majority of 7-6, the court in India, Supreme Court, held that the Article 368 of the Indian Constitution does not enable Parliament to alter the basic structure or framework of the Constitution. And there's a quotation or citation by two judges, Justice Hedge and Justice Mukherjee. But after tracing the history, we find that actually these principles did not emanate from India. It emanated from the scholar, a colleague referred to that, the scholar called, there's a Professor Conrad of Germany. He gave us a talk in some Indian university, and this idea was captured or was captured by some lecturers and some professors, and finally it reached the ears of some judges who, in the case of Golaknath versus State of Punjab, 1647, who applied those principles, and that was the first foothold in India, that case of Golaknath. Even though the court then did not accept any limitations on Parliament's power to amend the Constitution. So, regarding the Germans, it's not easy to see why a German jurist would propagate implied limits to amending the constitutional powers. Article 79.3 of the Basic Law of the Federal Republic of Germany, adopted on 8th of May 1949, explicitly bars amendments to provisions concerning the federal structure and to basic principles laid down in Articles 1 and 20 on human rights and democratic and social setup. The Germans were healing from the Nazi era, and it is for that reason that the framers of the Basic Law sought to create a constitution that would safeguard against the emergence of either the Weimar Republic's overly fragmented multi-party democracy or the Third Reich's authoritarianism. And there have been arguments in various cases in support of this. Now, in France, the same thing happened, where a scholar called Schmidt was where there's a scholar called Maurice Hariot, a professor of administrative law and constitutional law, published two constitutional treatises, and the difficult name it has, I can't read it, setting out the history of implied limits on constitutional amendment. Now, coming back to, I'm referring now how this has been discussed in Kenya. Yaniv Rosner, in his article on constitutional amendments, the migration and success of a constitutional idea, in the American Journal of Comparative Law, drew attention to the debate of the first American Congress, more particularly the debate that took place on August 1789. So there's a lot of discussion in the US, and I don't have to go to the cases. Everything is in that judgment. I've gone rather into some detail. Legal doctrines and principles are often traceable to a particular school of thought, and more specifically to a certain scholars who sought to elaborate them. The importance of this is to address the contestation regarding whether the basic structure doctrine was a creature of judicial craft, or even whether the courts are capable of creating doctrines. This is not to make a case for incorporation, or rather reading into our laws. All doctrines and legal principles are in existence. From this, however, it is evidence that the doctrine of basic structure was not invented by the judiciary in India and some of the other countries. It has been submitted that the doctrine of basic structure has yet to gain universal experience. And for that reason, we are asked to find that it is not applicable. I do not think it is necessary that before application of a doctrine or legal principle, the same must have universal application. I say this because not all legal doctrines and principles are universally applicable due to the differences in legal systems, such as the civil and common law. This is also because of our unique peculiarities, such as states due to our historical, cultural, and social systems. My thoughts on this are further fortified by our Constitution, read together with the Judicature Act, Cap 6 laws of Kenya, which allow us to apply the doctrine that are in line with our laws, more so if they assist us better to interpret and apply them. There's a lot of reading material which I've referred to. So directly is the doctrine. Is the doctrine of basic structure applicable to Kenya? The basic structure doctrine is not only new to is not entirely new to our jurisdiction. Much like the other countries, Kenya has had opportunity to grapple with the doctrine of basic structure in our circumstances. During our journey of constitutional making, we had the CKRC appointed in November 2000. The commission chaired by Professor Yash Palgai convened the National Constitutional Conference for discussion, debate, amendment, and adoption of its report and draft bill, famously dubbed the Bombers Conference, due to taking place, which was taking place at the Bombers. The Bombers Conference was convened and adjourned 3 times, out of which a draft was amended and adopted by the acclamation by the conference, sitting in plenary on 23rd March 2003, then handed over the Constitution to the Kenya Review Commission. However, before the conference was adjourned, there was a number of challenges to the validity or legitimacy of the entire constitutional review process and its outcome, one of which was the case that I've referred to, Timothy Njoya and others, versus CKRC. The applicants sought inter alia, that was 2004. The applicants sought inter alia a declaration that certain provisions of the Constitutional Review Act transferred, diluted, and vitiated the constitutional power of the people of Kenya to adopt a new constitution. The court held that the new constitution needed to be ratified through a national referendum, as the right to a referendum was a fundamental right of the people in exercise of their constitutional power. Ringera J., who is now retired, who was in the majority, concurred with the pronouncements of Kesavananda that Parliament did not have the power to alter the basic structure of our Constitution. And there's a citation here, which I don't have to go through, where Justice Ringera, and which means our courts, recognized the principle of, this is my submission, principle of basic structure. Application of the doctrine again arose in the case I referred to, Patrick Ouma Onyango. One of the issues that arose was whether Parliament, in its limited delegated role, had the power to debate, alter, or amend the Bombers draft constitution, which was the product of the view of the people. It was also questioned whether that interference by Parliament had the effect of elevating the members of National Assembly above the people of Kenya as sovereigns. The court, consisting of Nyamo, Wendo, and Mkule, held, and I think I should refer to it very quickly. We further find and declare that what will give purity to the process is the enactment of the proposals as a constitution by the people in the referendum. It is the enactment by the people which gives purity and validity. Yes, they are the touchstone of validity, the people. The applicants in their final written submissions did concede that constitutional power cannot be restrained. We exercise judicial power on behalf of the people, and we cannot restrain for them in making their choice. These are 3 judges of our courts speaking for the people of Kenya. We find and declare that the basic steps in constitution making are 1, popular consultations, 2, framing of the proposals, 3, referendums, or Constitutional Assembly elected and mandated. We find the challenge process has satisfied all the three steps. We find and declare that the process is not flawed. In our view, the real judges of the process are the people of Kenya in view of the past involvement with the process as outlined. I'm not going to go through all that. There's a lot of material which I will let you read when you get this judgment. Basically, it is to show that Kenya itself, due to the 2010, people discussed in depth the history and the problems that Kenya went through, the hyper amendments that we had gone through, and the result was the 2010 Constitution, and in particular, Chapter 16 and Articles 255, 256, 257, which I will be persuading you in this opinion that contains the basic structure that supposed to protect the people from amendments by even the delegated power, which is Parliament. After the promulgation of the Constitution in August 2010, there was a case of the Commission for the Implementation of the Constitution versus National Assembly of Kenya, where the National Assembly, by the Constitutional Amendment Bill 2013, sought to amend Article 260 of the Constitution in respect of the definition of state office. I'd already discussed that. Then there was the case of Priscilla Kivuitu. Then we have various cases. Attorney General versus Randu Nzai, whereby the court held that in view of the foregoing, the appellant's contention that the respondent's agenda of succession is unconstitutional has no basis in law. The respondents have a constitutional right to demand succession, but that can only be done within the confines of the Constitution as stipulated under Articles 255, 256, and 257 of the Constitution. Now, in all these cases, the applicability of the basic structure doctrine was not a substantive question of the courts. The courts were asked to determine, unlike the present one. So in this case, through my proposals here, which I don't wish to go through, and I have told you the art of brevity is not donated to everybody, and I'm not one of them. So I'll let you read. But I'd refer to what I've said here. That there was this decision by Justice Mativo in the Third Alliance case, Kenya versus another versus Head of Public Service, Joseph Kinyua, and others versus Martin Kimani and others. In that case, Justice Mativo said, he referred to this doctrine and he stated as follows: the command in Article 259 is instrumental in shaping the constitutional jurisprudence in this country. Call it by any name, basic structure, or whatever, but Article 259 provides the manner in which the Constitution is to be interpreted to maintain its fabric, which cannot be dismantled by any authority created by Constitution itself, be it the Parliament, the Executive, or the Judiciary. Couched in this doctrine are a few crucial aspects. First, that constitutions are considered to be the act of the people as the almighty sovereign. We see this as the power of the people recognized and documented in the preamble of our Constitution, which begins as follows, and I quote, "We, the people of Kenya, exercising our sovereign and inalienable right to determine form of government of our country and having participated fully in the making of the Constitution." So I've gone through this, and I invited you, as some of my colleagues have said, some of our judgments are long. Mine is 125, and I would not wish to read through it. I invite you to read carefully, but after going through all my arguments and citing various cases and showing the historical road we passed to acquire, to get this very important Constitution 2010, of which I'm sure all of us are proud of and all of us cherish, I came to the conclusion, my disposition on this issue, first issue, noting our history, context, and constitutional text, I find that the doctrine of basic structure is applicable to Kenya. Further, that the basic structure of a constitution can only be altered or denatured through the primary constituent power. C, it's my further finding that the primary constitutional power is the unbound power of the people to make or unmake constitution, and genuine exercise of the same can be identified by the 4 sequential steps of civic education, public participation, constituent assembly, plus referendum. So I've set out in the judgment what the basic structure entails. And I've set out and I've discussed the issue, where, can the basic structure of the Constitution only be altered through primary constitutional power, and what constitutes the primary power? I've discussed that, and that was my dispensation. So that is my dispensation in that question, and I invite you to read that. So in the interest of brevity of time, I'll go to another issue. Issue number 2. Issue number 2, whether the President can initiate changes, amendments to the Constitution, and whether constitutional amendment can only be initiated by Parliament through a parliamentary initiative under the Article 256 of the Constitution, or through a popular initiative under the Article 257 of the Constitution. I'll give a summarized view of this, which is contained in this opinion and judgment, and also one more issue. The other issue is the place of public, issue number 5, the place of public participation under Article 10 vis-a-vis the role of IBC. The other 3, I wish just to set out and read and state my disposition without going into the details, and I leave that to you to read when you have the time. Regarding question 2, Gatembu J.A. rightly observed that Article 257 makes no qualification of who may or may not promote a popular initiative, and there is no explicit bar against any person, including the President, from promoting a constitution amendment by popular initiative. It is therefore upon the court to interpret and determine the parameters of the same. Now, Justice Tuyot gave the historical context of highlighting the genesis of popular initiative, the clauses in the Constitution. This can be traced back to the CKRC final report, where the Commission noted that although the conference agreed the process of constitutional amendment, this must not be left entirely to Parliament. Different options needed further thought, particularly with regard to the exact modalities of engaging the constitutional power of the people. The Commission, in addressing the issue, recommended that that citizen and the civil society may initiate constitutional amendments through a process called popular initiative. This was then captured in the zero draft at Article 346, and the same was retained in the Boma's draft as follows, and I quote, an amendment to this constitution may be proposed by a popular initiative signed by at least 1 million citizens to vote. So the genesis of the issue of popular initiative was way back during the CKRC conferences. The same survived the Naivasha Accord of November 2004 and the Kilifi Accord of June 2005. And also, it was retained in the harmonized draft. The objective for the popular initiative, as captured by the final report of the Technical Working Group of Group K of the Constitution of Kenya Review Commission on Constitutional Commission and amendments to the Constitution held up to the creation of 2010 Constitution, the report said, a committee introduced a novel idea called popular initiative. This is an innovative where the citizen can only own motion by their own motion initiate amendment to the Constitution by way of a popular initiative, either in the form of a general suggestion or a formulated draft bill. The committee explained that their intention was a starting point towards curbing dictatorship by Parliament. 2-year JA went to hold that, contrary to the AG's submission that the intention of the popular initiative was to curb parliamentary monopoly for both people and state organs, the historical perspective demonstrated that the popular initiative was a preserve of the citizens. It's for this reason that I concur with Kiage J when he concluded that the popular initiative route must be citizen-conceived, citizen-initiated, and citizen-driven process, and the citizens are the ordinary people, whether as individuals or as organized civil groups. Regarding the assertion that the President can initiate process of constitutional amendment by way of popular initiative in his capacity as a private citizen, two pertinent issues arise. First is the fact that Article 257.5 subscribes the President a role in the amendment process. Article 257.5 provides that if a bill to amend the Constitution proposes an amendment relating to matters under Article 255, the President shall, before assenting to the bill, request IEBC to conduct a national referendum within 90 days. The import of this provision is it assigns the President the power to decide whether or not to hold a referendum. To ensure the integrity of the process of constitutional amendment pursuant to Article 257, we cannot have the President playing the role of umpire, who is expected to be neutral and act in the interest of the nation, in a process where he is also a player advocating for his own personal interests and agendas. Clearly, there would be a serious conflict of interest. This would be detrimental to the interests of the people and the nation. Second is that the President ceases to be an ordinary citizen the minute he takes office. Article 131 describes him as the head of state and government, who exercises executive authority of the Republic. He is also the Commander-in-Chief of the Defense Kenya Forces. He chairs the National Security Council pursuant to Article 240, which exercises supervisory control over national security organs, including the Kenya Defense Forces, the National Intelligence Service, and the National Police Service. He is also the symbol of national unity. He plays the various powerful roles pursuant to Article 132, including appointing Cabinet Secretaries, Attorney General, Principal Secretaries, High Commissioners, Ambassadors, as well as diplomatic and consular representatives. He is empowered by virtue of Articles 132, 4D and E to declare a state of emergency or declare war, respectively. He may also, pursuant to Article 192, even suspend county governments, either in emergency arising out of internal conflict or war, for any other exceptional circumstances. By virtue of holding this office, the President is accorded immunity with Article 143. So you can see the special position of the President. And we are saying, and I'm saying that the President cannot act as a promoter or initiator, even if you have to use that name, initiator, you cannot commence or get involved. In this particular case, there is evidence that not only did he start the process, but he was also involved throughout, and all steps taken by others was the genesis was his own actions through the Gazette notice and the legal steps that he took. This power and control that the president exercises by virtue of his position was evident in the inception of the amendment bill, as rightly pointed out by the learned judges of the superior courts, right from the handshake that was between him as the elected president following the contentious 2017 general elections and rerun, and his competitor and challenger, Honorable Raila Odinga. He then proceeded to appoint that. So I gave, in this narration, I give the history of all the steps and that he was involved in directly, in the building bridges to a united Kenya, from a nation of blood ties to a nation of ideals, the appointment of the teams, the Gazette notices throughout. The first step had a domino effect, and throughout he was involved, and the government's role was also very clear. The difference in the amendment bill that was launched on 25th November 2020 from the amendment bill contained in the BBI Steering Committee report presented to the President on 26th 2020 are better contextualized in discussing the place of public participation under issue number 5. My conclusion there is that on whether the President can initiate a popular initiative to amend the Constitution under Article 257, it is my finding that he cannot. Issue number 3, on whether the second schedule to the Constitution of Kenya, Amendment Bill 2020, was unconstitutional, I find that on issue number 3, I find that the second schedule of the Constitution of Kenya Amendment Bill to have been unconstitutional. On question number 4, it is my finding that pursuant to Article 143(2), no civil proceedings can be instituted against the President or person performing the functions of the office of the President during their tenure of office with regard to anything done or not done contrary to the Constitution.